Welcome to the program. My name is Marty Schenkman. I'm joined by two friends and colleagues, Jonathan Blotmacher and Robert Keebler, who I'm going to call Bob. But we are going to talk about estate planning after the election and what it means, what practitioners should be saying, what they should be doing, how they should be planning, and what may come about. We're recording this session in order to get this done on Thursday, and that's going to be a bit before it plays. So today, as we're recording this Thursday morning, the Senate is 52 Republican, 45 Democrat. The House is 205 Republican, 109 Democrat. So by the time this plays, there may be finality on the status of the House and whether or not the Republicans control. But it looks like that's going to be the result, a sweep, White House, Senate, and House, and has profound implications to all we do as estate planners. And we're starting to ponder it because we all have to ponder it. Before we get started, I'd like to acknowledge our two sponsors. We're not doing a PowerPoint because of the quickness in which we tried to get this completed. Peak Trust Company, which is in Alaska and Nevada, is really a long-time administrative trust company and serves as a trustee of trusts in two of the top trust-friendly jurisdictions. I have one of my own family trusts with Peak, and I've been with them since 1998. So I'm a customer as well as a colleague, and they've provided great service. The second sponsor is ILS, Interactive Legal Systems. Is that right? I always call it ILS, Jonathan. I don't think I've ever said the full name.
Interactive Legal Systems is correct, Marty.
And it's a document generation drafting software program. If you have not transitioned your practice from using in-house manual forms to document generation generally, you should take a look at the process. It's incomparable. And AI is going to continue to revolutionize the profession. You need to get on board with document generation. And ILS has an incredibly comprehensive system. It gives you an incredible array of form options, planning options. And I can say from my experience, it's revolutionized how we draft and how we plan. It's not just the drafting efficiency. When you get involved in using document generation, it changes your thought process with how you approach planning. And I think for practitioners that haven't taken the plunge, it will give you the ability to be much more nimble and as practitioners being flexible in the new environment, and we have a dramatically new environment with the Republicans' victory. I can't say it's a sweep as of Thursday, but it looks like it's going to be. You need to be nimble, and drafting software can do that. If you Google ILS or Peak Trust, you can get either of their contact information. So let me start our discussion with a comment that is incredibly obvious but important. And I'm going to ask Jonathan and Bob to chime in on this. And then we're going to have Jonathan give an overview of some of the political landscape and some of the things that are relevant to what might happen in Congress. We need to have an understanding of that because it will affect what we do. And then we're going to talk about planning. I hear some background noise. I don't know if it's somebody ruffling papers, but we should be careful not to do that. So to me, key number one, and we don't know all the answers. We're going to talk about what we think some of them are, but the key step number one, we have to communicate with clients. I think it's imperative that we communicate with clients. And I'm, after this webinar, going to draft a communication and probably an article to send or a paper to send to clients because the world has changed. Now, I think it's fairly safe to say that we all three generally, and there's exceptions we're going to talk about it, generally feel that people should proceed with planning. And we're going to talk about what that planning looks like, how it's different, how we present it differently to clients. But we need to explain to clients what this means, because many clients are going to have a very different feeling about the potential risk of estate tax costs based on the election. And I don't want a client to be upset with me that I'm going to finish planning that's in process, and they're going to say, why'd you do that? There's going to be probably no likelihood, or a small likelihood, that the exemption is going to decline. It'll probably stay where it is with Republican, especially if they sweep. We need to communicate to clients that the election has occurred and what the changes mean. And hopefully the content of this preliminary discussion will give you all ideas to communicate. And we'll do more webinars as it starts to play out and we start to see more of what's happening in Washington and refine our thinking on it. Bob, why don't you chime next? What do we say to clients, and how do we communicate with them, and what do you feel about that?
Well, I think totally reasonable that there'll be no changes in the estate tax law for the next at least 4 years. Okay, so we're going to have everything I've read is the Tax Cuts and Jobs Act, provided we have a Republican House, will be extended. And President Trump and the Senate will be able to use a process called reconciliation, even though they do not have the requisite 60 votes in the U.S. Senate. So they can use reconciliation to do that. But reconciliation has a time frame to it. Okay, that's that 10-year time frame, Marty. So even if we extend this 10 years from now, we'll be doing the same dance again. Okay, so we kind of have to start there. But there's so much else that can be done. We'll talk about that today. But for our largest clients, absolutely nothing has changed, because
Define
they should
large
continue.
for people.
Over $50 or $60 million.
Okay.
I mean, what will change dramatically is people worth 14 million to 30 or 40 million who now can take a deep breath and say, wait a minute, I don't have to do this in the next few months or few years. The other thing that will change dramatically, and this is important, I represent a lady who's 90 years old. She has about $30 million of Apple stock that she bought many, many years ago. And she's 97. We do not have to gift that Apple stock away, thread the needle with that low basis stock. We can wait, and perhaps she dies with that, receives a step up, but still has a $14 million exemption. So the calculus has changed a little bit.
Jonathan, any thoughts on what advisors, and I'm going to use the term broadly, financial advisors, accountants, attorneys, insurance consultants, what should people be telling clients? And we're going to get into obviously more details as we go through the implications of all this.
Well, I believe that the Republicans will wind up with a sweep, but that doesn't mean they can do whatever they want. The only way they can get tax changes through is through budget reconciliation.
We're going to come back and let you talk about all that. I just want to first start with communicating to clients, and then I'm going to turn it over to you to explain.
I mean, Marty, it's all tied in together, but let me point something out. Let's say you have a client who has 10 million, putting aside whether they have a spouse, but the client has 10 million and figures, they're not going to reduce the exemption. I'm golden. But the client will hope that the value of his or her property will go up. And even if you only make 7% on the money, it means the value will double every 10 years. So his 10 million or her 10 million will be 20 million in 10 years, and will be, 40 million in 20 years. And today, when I was at physical therapy, I held the door for a woman who said, stay young, young man. And I'm almost 80, but it was amusing. And I said, well, how old are you? She said, I'm 90, and I wish I hadn't lived this long. But people continue to live to really great ages. So if you have an 80-year-old, someone like me and my wife, and if our money grows at only 7% a year, which would be disappointing to me, it means that even if only one of us makes it for about 20 years, instead of us having 10 million or 20 million, we'd have 40 million. And keep in mind, in that time, the political landscape will change. And as a consequence, do your planning now. And in fact, Marty, I think that there's a reasonable chance that the exemption will be reduced as current law has it. And let me point out,
We're going to come back. I want to give you time to talk about all that. But I think the take-home message for the first topic that we wanted to cover is we need to communicate. And planning may be different, like Bob explained. The pressure may be different for some clients, but we're going to talk about a lot of other reasons clients should plan. And that's important to start educating clients about. So I think communication is critical, and we should all start planning to get out some type of email blast, physical letter, however you communicate with clients. The next thing I wanted to do is turn it over to you, Jonathan, and let you explain the stuff I know you were chomping to get into. Filibuster, reconciliation. What are some of the mechanics that we should understand in Congress that may affect what's done? And please specifically address with some more thought and detail your comment on whether or not and why you think the exemption may or may not actually decline in 2026, because that's really critical.
well, it is critical, Marty, and you go back to when George W. Bush ran and won the presidency in 2000. And he had announced that the repeal of the estate tax was his #1 domestic agenda. So he won, and I knew, and everybody knew, that this meant there was an end to the estate tax. But it didn't happen. And the reason was his advisors said, look, yes, you can repeal the estate tax, but that means you can't give as much income tax advantage or reduction that you also want to give people who, like you, have a lot of income. And indeed, he did not have it. They put it in to be repealed, the estate tax to be repealed after 2010. And of course, that happened for 1 year where people were given a choice, either have property in their estate and get the stepped up basis, or not have property in their estate and pay no estate tax. But remember that there is at least a reasonable chance that the political landscape will change in the next four years. So, you may say, well, they're going to reduce the exemption. I don't have to worry because it's never going to happen. Trump won't let it happen. He may, because he's going to pay a political price for not having it cut in half, which has been on the books. So they've got to make a decision. Where do they want to spend the money? And they may decide that allowing the exemption to be declined, because most people aren't going to die in the next 4 years, is better than not being able to give more income tax relief to people. So you just can't tell for sure. Again, George Bush said, repeal the estate tax is my #1 domestic agenda, but it really didn't happen. So,
Jonathan, isn't that also President Trump made a number of promises on income tax reductions already, Social Security, tips, I think overtime. So there's going to be a material cost to carrying those through. You think that might be enacted and then offset by letting the exemption decline?
well, Marty, the Social Security Administration pays out $1.5 trillion a year. And Bob, I don't know if you know, I actually tried to find out how much income tax is paid on Social Security payments, and I couldn't. But let's say only half is subject to it. So you have 750 million each year is subject to income tax. And let's assume that, only the effective rate of tax is only 20%. I think it probably is higher than that. Well, that's $150 million a year. That's a huge price to pay, putting aside reducing the tax on tips and overtime. But, he can't do it all. I mean, there's a limitation to what people will agree in the government to what kind of debt we can take on. So if he wants to provide some relief with respect to the non-income taxation of Social Security payments and overtime and tips, he's got to have something to offset it. Now, again, the reduction in the estate tax is already in the law. They don't have to advertise that. So I think there is a pretty good chance that you will not see the exemption restored back to where it would be, but for the fact that it's going to be cut in half in about a year.
Can you take a couple of minutes and just go through some of the mechanics of reconciliation, filibuster, and so on, just to explain how this may play out and affect what might be done?
Yeah, the rule in both the House and Senate is, as a general matter, once a senator or a congressperson gets the floor, he only loses his ability to speak before any vote can be taken if he either or she voluntarily does it, or you have the House or the Senate say you're through speaking. But as a matter of courtesy, they let people talk for as long as they want. That is known as filibustering. And very often in the past, we've had bills that have been up and some congressman or senator doesn't like it, and he or she will get up and they will not stop talking. In fact, I can remember a number of times people would get a telephone book with 20 or 30,000 names. And when he or she'd really run out of things today, they'd say, I think, and they'd go to page 1, I think Mr. Aaron will be on my side. And then they'll go through all the A's and all the B's and stuff. And eventually they say, okay, we're going to take this bill off the docket, and then it's just not voted upon, and the bill is killed through this fact that there is this procedure of basically stalling it to the very end. The House can get rid of someone speaking by a simple majority, but the Senate has a rule that you need 60 senators to stop someone from filibustering, continue to talk and not yield his position in the Senate. Now, there are 2 exceptions to that. One is for appointments of federal judges, and that means that if you have 60 in favor of someone, they just vote and that's it. That's in the Senate. The other one is budget reconciliation. If you have, someone can try to lobby, but if you have 60, you don't need the 60 votes to get them off for budget reconciliation. It's a simple majority. And that's what happened with respect to Barack Obama when he won in 2008. He was able to stop that because he made a lot of these changes, including for Obamacare, which the Republicans really didn't want, but he did it through budget reconciliation. And that's what Trump did back for the 2017 Tax Act. So there's a very good chance that the Republicans can get through any tax changes they want. They can also get judicial appointments through, but not much else. Again, they are not going to have 60 votes in the Senate to stop a filibuster, but they can't do it for anything other than budget reconciliation, which are tax changes. And again, Trump has to decide, what do I want here? Do I want income tax reduction? I made promises on no tax on Social Security, no tax on tips, and no tax on overtime. That's huge. It would be, I'm going to guess, several $100 million a year. And I just don't think that he can.
You mean billion, Jonathan?
I'm sorry, you're right. Billions. Hundreds of.
We should only have a budget where a couple $100 million means something, right?
Yeah, as one of the great senators from New York once said, a billion here, a billion there, it eventually adds up to real money. So I just don't think that there's much of a chance that they're going to be able to get everything they want from a tax perspective. Now, one of the things that Trump is also asking for, and maybe he will get it, and again, they could possibly do it as part of budget reconciliation, are tariffs. Because he claims that I'm going to put tariffs on everything coming in from China and from Mexico and other places, and we'll be awash with money. I don't think that's going to happen, and I don't think it's going to happen in budget reconciliation. So I think they're going to have to give up on getting everything they want from a tax perspective. But we'll
Jonathan, couldn't they then use tariffs to offset the tax cuts that he wants to make?
Well, yes, he could try that, but that's a very complicated matter on where do you put the tariffs on, which companies, which goods, what services. And they haven't really thought it through. I just don't think that they're going to get the kind of things that happen. Also, there's just no question that when you put on a tariff, it means the American consumer winds up paying more for it. So for example, let's say, well, no, we're going to make people buy American cars. Well, if you take away the competition from foreign car manufacturers, what's going to happen? Lower competition, higher cost of those goods. So there's always an offset here. And I seriously doubt if they're going to be able to put in enormous tariffs on Chinese and Mexican and even European goods, which they're talking about. And again, remember, tariffs are very retrogressive in taxation, and people will really feel it at home, and that will cause the cost of goods and services to go up. And the Republicans really ran on the fact that Biden had allowed inflation to get entirely out of hand. The bottom line is this is all very complicated, but I don't think you can assume there's just no way that we're not going to get back to a $15 million per person estate tax exemption. I think that would be one of the things that's very easy to give up. It's already in the law. You don't have to make any change, and you don't have to come up with something to offset it. It's already in. Again, go back to what George W. Bush said. And again, he said, my number one domestic agenda is the repeal of the estate tax, and it never happened. And I think that it's probable that the exemptions are going to go down. And we'll talk later, as you know, Marty, about, well, if you think it might happen, what should you do now?
We're going to pivot in a second to you, Bob, and talk about income tax issues. But I want to make a comment and then address something with you, Bob, before we pivot. So, I mean, the logical answer to me, and I want to give a slightly different perspective to emphasize what Jonathan said. Jonathan has made a case that maybe the exemption won't go down. We can't guesstimate a likelihood of that happening or not happening. But when you look at the magnitude of wealth that people have that are doing this planning, what is the cost or downside of the planning? And I think, as Bob said, I'm going to steal his phrase, the calculus. I think he said the calculus has changed. It's changed here. But think about it. If somebody is worth $20 million, and I'm going to throw out a number, don't get upset if it's too high or too low, depending on how you practice. But let's say it costs 25 grand to set up a SLAT, 20 grand, whatever the number is. And even estimate high, 25 grand. Relative to the wealth that the client involved in doing that planning has, relative to the potential tax savings over time that client may experience if the estate tax is not repealed, the cost of doing the planning is insignificant. The real issue is doing the planning smart, and we'll talk very briefly about that because it's not our topic, by preserving sufficient access to the assets. It doesn't make sense to me, and it makes even less sense when we talk about other factors like income tax and asset protection, et cetera. That doesn't make sense just even from the potential risk of an estate tax for somebody to defer or not proceed with planning, because what Jonathan said earlier is critical. Even if you get a 7% or less than 7%, even if 5%, think of the compounding over the remaining growing life expectancy of the clients. The cost of doing the planning, so long as they have adequate access to their resources, is insignificant compared to their wealth. The concern I have, Bob, is, and let's talk about this for a minute, then we'll flip it to income tax, is a comment you made to me when we were talking last night about this, is about estate planners remaining relevant. My worry is, I agree intellectually with what Jonathan said. I think the comment I made about the cost of planning versus the potential benefit, even if it doesn't pan out and the exemption doesn't go down, is not a big investment for somebody to make. It's inconsequential. My concern is, will clients buy that? I think we start to sound like, the little, what was the little boy crying that the sky is falling? Chicken Little or whatever it was.
Chicken Little.
Chicken Little. I think clients are going to be loath to be comfortable proceeding with planning that they find costly and complicated, even though the cost is inconsequential relative to the wealth and the benefits could be dramatic. Can you comment on that and talk about generally the relevance of planning, and then we'll segue into income tax?
Well, I think for the very wealthy, nothing's changed. Okay, you'll start there. And for people worth less than 14 million, nothing has changed either for the most part. It's for people between 14 and 30 or 40 million dollars where the dynamics have changed, because if I retain my property, I get a step up when I die. So it says not to give it away. Now, to Jonathan's point about money doubling every 10 years at 7.2%, if you have a 65-year-old lady who gives away $5 million, by the time she dies at 85, that will be $20 million. Simple math. We've all seen it in our clients over time. So I think we start there with the planning should not be dead. Flexibility and keeping the ability to use some of that money is what's critical. So having husband create a trust for his wife and granting her a GPOA if she has extra exemption might be the best of all possible worlds, okay? Now that whole idea of then wife turning around and doing a trust for her husband is where it gets complicated, and maybe some of that will not be as popular, Marty. So I think that's one thing. But you have to remember, estate planning, at least the basics will become or will continue to be relevant. You just have this tremendous birth curve right after the war, okay? So 80 years ago. And gentlemen came home, they met a girl, they got married, they started a family, and now those children born from 1945 through 55 need a lot of estate planning. So there's plenty of work out there. It's just going to look different.
How do you feel about clients' reaction? That's what concerns me. We can have an intellectual discussion about why estate planning makes sense. And we're going to talk much more about why it makes sense from asset protection, income tax, and other factors. But I'm concerned that clients, the fear of a massive estate tax is what often motivated those clients in the, even from 10 to 50 million in that wealth strata to come in for planning. With a Republican, if it turns out to be a sweep, which is Jonathan's prediction, so I'm going to hold him to it and what it looks like, but with a potential for a Republican sweep or an actual sweep, are clients going to be willing to do that? Or are they just going to say, listen, you know what, let's see what happens. Nothing. I think it's highly unlikely, and one of you, I forgot who started our conversation early on by saying it's highly unlikely we're going to see like an Elizabeth Warren or Bernie Sanders type of tax proposal enacted in the next 4 years. It's just not going to happen.
It's not going to happen.
Right.
But
so
to
how do we
Jonathan's
motivate
point,
clients?
Well, one is there's not 100% certainty that we won't sunset, okay? So we have to start with that. So some people should be still keeping their planning. And you want to start with really strong financial analysis of how much money do my wife and I need to live on? Because maybe it's going to become, maybe we should be giving things away for a combination of asset protection, shifting income into our children. There may be a large number of just family wealth reasons aside from the estate tax to do this planning. For most people, though, they do not need the urgency of doing something in November or December may be reduced, okay? Because part of what was driving that before was a concern that if there was a blue wave, that the Elizabeth Warren type bills would become law. And now that concern is gone. Yeah, that concern is gone. We don't have to worry about that for 4 years. Because again, President Trump would veto anything that was that awful. So I think we continue on the path for very wealthy people, but lawyers shouldn't give up. They should just pivot to doing more IRA work. There's a lot of planning that can be done with IRAs, Roth conversions, taking money out of IRAs to buy insurance.
Let's just introduce the topic broadly, and then I'll let you take it away. So one of the things that's not given as much attention, which should be, because if estate tax, as I've just described, and I agree with him, I can't imagine seeing a Bernie Sanders type estate tax proposal getting enacted for the next 4 years and maybe beyond that. So that talking about planning for the exemption and we'll talk about asset protection, it still makes sense. I don't think it's going to resonate nearly as strongly with clients. Income tax planning is something that always makes sense. And even if they reduce rates, and I'll quote you, Jonathan, what you said when we were talking also last night, even if there's a rate reduction, it can't be that large. And I think you're probably right, because there've been all these promises on tips and overtime and other things. If you give all those benefits, how can you possibly also reduce the rates materially? But when you take state and federal tax rates, even if there's a reduction, even if it's 5%, which I think is high, there's still going to be a material income tax. So talk in general, and IRA planning is certainly one of it. Talk about what estate planners can do to pivot and educate clients about income tax planning opportunities. And Jonathan, then you should talk about slats or salty slats or non-grantor trust, whichever acronym or name you want to use. Bob?
Well, I think the key for most of my lawyer friends is to identify the techniques where there's already a 60-70% overlap with your current skill set. Not to go into things that you normally wouldn't do, but there's a lot of good work that can be done in the IRA area. Roth conversions, taking money out of IRAs to make gifts, taking money out of IRAs to buy insurance. On the estate administration side, there's a lot of income tax work there that is very relevant, and lawyers have somewhat drifted away from that in the last 5 or 6 years because they've been very busy with other things. As a sidebar, I think estate administration, the portability election may be more relevant than ever because, Jonathan, the way I understand it, we're going to have to deal with this again in 10 years. If we use reconciliation, the estate tax will come back, the sunset will come back in 10 years.
Well, Bob, of course, it can come back even earlier than that, because whatever you do, everything that was a tax reduction can be restored. The Byrd rule in the Senate says, unless you have 60% vote otherwise, any law which reduces the receipts of the federal government must expire within 10 years. That's why the 2001 Tax Act, which George W. Bush got through, was going to expire in 2010. And Mitch McConnell, then the head of the Senate, and John Boehner, then the head of the House, and Barack Obama got together just before it expired. In fact, they made a change that actually was retroactive to the day before. And that could happen again. But if you have the Democrats come back in 2000, let's see, it would be 2008, then you can have it go back and be changed right then and there. So it's not a 10-year wait, it's only a 4-year wait. And it could come back with some very harsh results. The bottom line to me is that do your planning now. And in fact, Marty, if someone says, okay, I'm willing to do something now, but if this never comes to pass, how can I undo it?
That's an interesting point, and that's the kind of conversation that we had in 2020 and 2021 and did program on it, because some of the concerns were, what if the Democrats then would enact Bernie Sanders, Elizabeth Warren, Wyden type, really harsh estate tax change, but what if they don't? So I want to kind of get my planning in place, but I want to be able to modify it or even undo it if in fact the laws don't change. And that's certainly an approach that could be used, although I don't agree with it, and we'll talk about why in a minute, along the lines of what Jonathan said. Jonathan made a pretty good case as to how you cannot, should not, and clients should not dismiss the potential that the exemption decline in 2026 may still happen. There may be more benefit politically to carrying out income tax reductions than modifying an already existing estate tax law change of the reduction in exemption. So at that time, we talked about a couple of techniques. I'll mention them, and we can talk about a minute or two if you'd like. So one concept is you make a gift to a Q-tippable trust. You make a gift to a trust that can qualify for the marital deduction. And if in fact you decide you want to use your exemption, you have until the gift tax return filing deadline, which is October 15th of 2026, if you do it next year, to make a decision whether or not you're going to elect to have that transfer to this Q-tippable trust qualify for the marital deduction. And if you choose not to elect a Q-tip marital deduction for it, then in fact you've used your exemption. So that seems like a clever approach for fence sitters, because they could put assets in a trust, and if they find out that by October 15th, 2026, that the exemption has in fact been allowed to decline, and you're certainly going to know before then they can not elect the marital deduction and they've used their exemption. If in fact the Republicans have sufficient clout and put the political capital on maintaining or extending the bonus exemption past 2025, then you could choose to make a Q-tip election, so it's qualified for the marital deduction. You've used no exemption, and the spouse is a beneficiary, can presumably through distributions get the assets back over time. Any comments on that? And then we can talk about some other techniques.
I think, no, that's a solid strategy. You have to watch your deadlines on these estate tax returns, because
Yes, you do.
if you on the Q-tip, there's no get out of jail card free if you miss an inter vivos Q-tip election. The IRS can't help you. You miss a testamentary Q-tip election, the regs allow the IRS to grant you relief, but there's no relief on these inter vivos elections. So if a lawyer is going to do that, he or she really needs to bird dog the filing of those returns, make sure they happen. But that's the type of flexibility we have to build into our planning, Marty. It's just do some things, and maybe we undo them if everything works out the way we're anticipating.
I think it's going to vary. Just sorry to interrupt. It's just going to vary by client, because different clients are going to have different perceptions and feelings about all this. So I think a large number of clients understand and appreciate the importance, and we'll talk about this later, of asset protection planning, and they're good planning at their wealth level anyhow. Those that are fence sitters, maybe this Q-tip is a way to address the potential risk that Jonathan has explained, that there may be in fact the reduction happening. Jonathan, any thought? Does that make sense as a strategy for those fence sitters?
Well, it does, but there are a couple of other things that people can do. One is that if you put assets in trust for the family, and in some states that can even include yourself, you can give one of the beneficiaries the opportunity to renounce or disclaim his or her interest in the trust. And in most jurisdictions, you can structure the trust so that if that particular beneficiary disclaims, the entire amount transferred will be treated as though it was not transferred as a qualified disclaimer, which means it would go back to the grantor. In fact, you don't even have to tell the IRS about it, because from inception, the transfer was never made for estate and gift tax purposes. So for someone who says, well, I don't even want my wife in this, you create a trust and you give someone whom you trust, maybe it's a child, maybe it's a grandchild, maybe it's a sibling, with the power to disclaim their interest in the trust. And the trust provides that if that person makes a qualified disclaimer, they have 9 months, of course, from the time the transfer is made. So it would take us out to about, September of next year. You can go ahead and have them make the disclaimer, and it would all revert back, and you don't even have to report any of that to the Internal Revenue Service. And I think for a lot of people, that probably makes good sense to consider that. The other one is if you don't have
wait, don't go on to another one. Let's talk about this one for a minute.
Okay.
So this is a perfect segue to plug ILS. So lots of practitioners may say, I've never drafted that kind of disclaimer. I'm really uncomfortable. I don't know what to do. Where do I get language? Can I get some language? What do I do? Well, if you use drafting software, all you have to do is where it says disclaimer by named primary beneficiary, and that may not be the exact language, but it's just a line item. Watch the following. Jonathan, you got to watch. You push the button. You click that little dot. You now have the provision.
Yep.
So this, but all the different things like the Q-tippable trust, the disclaimer provision, and some of the other things that we're talking about. This is why document generation software is so critical to making your practice flexible and efficient in terms of billing and everything else. And I think the comment that I said earlier, and I know I interrupted you, Bob, and I apologize then, I'm apologizing again, but I think different clients have different temperaments. And if you can pick techniques that are comfortable for the particular client, they're going to be happier. So some people will like the idea of the Q-tippable trust that they can then have until October of 2026 to decide what to do. So if Jonathan's right, bam, they've used their bonus exemption. If Jonathan turns out to be wrong and the Republicans let the exemption decline, they just don't make the Q-tip election. The disclaimer, I think, is an interesting concept, and I want to suggest at least that practitioners consider the following. If a client's going to proceed with planning, I think a lot of people were surprised by the election result, especially the magnitude of the Republican victory, and they're going to be processing this for a bit of time. So if they're unsure and waffling about whether they plan or not, Jonathan, what's the downside of building in the disclaimer provision? So 6 months after finishing the trust, whenever they do it this year, next year, the client decides that they're uncomfortable. What's the downside of having that done?
Well, the only reason is that maybe the person whom you've given the power to disclaim won't do it. But typically you'll have someone, some child, some grandchild, some brother, some sister, whom you could count on as being willing to make the disclaimer. So I think there's very little downside in it. I've used it for my family, in fact. I've never had the disclaimer done, but I built it into trust for my own family because I just wasn't sure as to whether or not we wanted to make it complete. So that's something you can do. Another idea, which
So don't go on to another idea yet. I'm not letting you get off of this one yet. Why wouldn't practitioners want to think about doing it not just for the client, but for themselves? No practitioner wants an unhappy client. So even if we explain all the things that Bob talked about, that we're talking about now, why not just build it in just as a safety valve? So if the client down the road just feels uncomfortable, it's just there. Might this not be a good thing to protect practitioners from unhappy clients?
Well, I think that's right, Marty, and there's even more that can be done. As you know, I helped develop a concept called the Special Power of Appointment Trust.
Jonathan, I'm interrupting you again. You keep wanting to leave the disclaimer. It's such a good idea. I want to bother you another minute. The one downside that I've heard raised on it, then I'll let you go on to SPATs because I know you're just dying to talk about SPATs. I know you love it and it gets you very excited, and we're going to let you talk about it. Might including this disclaimer provision make the gift incomplete? Is that a worry?
I don't think so, Marty, because it's not up to you. It's up to the person who is the principal beneficiary who has the power to disclaim or not. So the gift is complete and the person can make a disclaimer. And if they make a disclaimer, it will revert back to the grantor if you structured the trust that way. And it will be as though the transfer was never made in the first place. It doesn't have to even be reported to the Internal Revenue Service. And as long as you have someone in the family that you're confident that if you ask them to do the disclaimer, they would, which means it would come back to the original transferor, I think you're A-OK. And a disclaimer itself, even though I've refused to accept this property, I've disclaimed it, it's now going to go back to the grantor of the trust. That doesn't mean that the disclaimant has made a gift. That's absolutely clear under section 2518 of the code.
So before you go on to SPATs, let me just segue. So one of the concepts we've now talked about is building in flexibility so people that now realize what Jonathan said, maybe there's a chance the exemption still goes down, but they're waffling. They could do a gift to a traditional, typical slat that is a pot trust, sprinkle trust for family and spouse with a disclaimer provision. They could do a Q-tippable trust and defer making the election. What about rescission, Jonathan? Is that an option in planning? And then we'll go on to the next concepts.
Well, there are some cases that state that if you have someone go in and just basically do a rescission of the transaction, it doesn't count for tax purposes. The law is not anywhere near as well as developed as it is for disclaimers, but there are some cases which say, yes, you can go ahead and do a rescission and it will be treated as though the property was never transferred. And you are not limited to the 9 months. In fact, there's some law which says as long as you do it in the same tax year. So if you want to use rescission and you say, but I want to wait until the end of 2025, you could create the trust in the beginning of 2025 and have the rescission done in 2025 on December 31. But
That's a very important point. Let me just emphasize what you just said. Don't do it this year if the client wants the option for rescission. Wait to next year.
Right, but they'd have the same thing with a disclaimer, because
Correct.
you got to do your disclaimer within 9 months, which means if you start this year, it's got to be done before, September of next year. You can't wait until the end of the year. And as Marty said, if you do something like a Q-tippable trust, where the grantor of the trust can wait, in fact, if he makes the transfer next year, say in January of 2025, you'll have until October of 2026 to decide whether you want it to qualify for the marital reduction and not use your exemption, and maybe your spouse will give it back to you, or you go ahead and you just have it qualify for the marital reduction and get it back through your spouse.
So those are ways to build in flexibility and giving the client ways to get around it. I don't think that's necessarily the right approach, because to me, from an asset protection perspective, regardless of what happens with the estate tax, this all makes sense. But clients, I think, will like that. And I think for a client that's unhappy, some of these concepts could be very valuable. Let me now segue back to you, Jonathan, because I know you want to talk about SPATs. But the broader concept is, and I'd like you to first address it in a broad context. Now that we know for 4 years we're not going to have a harsher estate tax enactment, and I think we can even say it with some finality that it's not going to happen. But maybe I'm going to use Bob's phrase again. The calculus has changed. Do we want to give clients even more access to the trust so that they're comfortable doing the planning? So instead of the doing a slat or non-reciprocal slats, what about a DAPT, hybrid DAPT, or SPAT to give more access to the client so they're more comfortable going ahead with the planning, because they may not be as worried about the estate tax as they were before the election? Thoughts, comments?
Well, Marty, I think that makes good sense. In fact, as you know, the reason that my brother and I got involved and lobbied in Alaska for the Alaska Trust Act, which allows someone to create a trust for himself or herself. In other words, you create, or as the English say, settle a trust for yourself. That's known as a self-settled trust. Throughout the United States, until Alaska passed a law, the law in every state that at least I'm aware of, even if you were a purely discretionary beneficiary, even if you weren't trying to defraud a creditor or harm a creditor, your creditors could always come in and say, hey, he created this trust or she created this trust. Because they can get it back, creditors can attach it. That was the law throughout the United States. And the reason that I went ahead and pushed for this is that clients would always say, but what if I need the money? How can I get it back? And, I can't create a trust for my own benefit. So my brother and I tried very, very hard to get the Alaska legislature. In fact, we spent a week in the rain in Juneau, met with every legislator and the lieutenant governor to try to get it through, and eventually we did. And it allows you to go to Alaska. There are now 22 states that permit it to create a trust or settle a trust for your own benefit, and it will not be subject to the claims of your creditors, provided you weren't trying to defraud someone in doing that. And in fact, after the Alaska Trust Act passed in 1997, I was invited to the annual meeting of the bankruptcy judges of the United States. And they're all federal judges, and they asked me to talk to them about this law in Alaska. And they said, why did you do that? And I said, well, I didn't do it so people could cheat their creditors. In fact, the statute says if you're trying to cheat a creditor, this won't work. It's still going to be subject to your creditors. I did it so people would not be hesitant in making transfers for estate planning purposes. And every judge who made an indication, not all of them did, there were about 60 of them there, they said, if you could establish that the reason you did this was for estate tax planning purposes, I wouldn't touch it. You could do it all day long. And indeed, we have a private letter ruling, I think it's 2009-44002, in which the IRS agreed that if someone goes to Alaska, creates a trust for his or her own benefit, that, and it's not subject to the claims of the creditors because they weren't trying to defraud or hinder or delay a creditor in creating of the trust, it will be excluded from that person's estate. So you can go to one of those jurisdictions, create a trust for your own benefit, and it should be immunized from claims of creditors, which means it should not be includable back in the client's estate. Now, if you
So,
do that, I strongly recommend you have an independent corporate fiduciary who will be believed when they can say, look, there was no understanding of any kind that the grantor would definitely get property back if he or she wanted it. So that's really something you should consider, or consider a SPAT.
what's a SPAT?
A SPAT is a special power of appointment trust. The law seems abundantly clear. In fact, if you take a look at the commentary to section 505 of the Uniform Trust Code, it says, yes, if you create a trust for your own benefit and the trustee can give you property back, it's going to be subject to the claims of your creditors forever, which would bring it back into your estate. And that's true throughout the United States, except for the 22 states which have passed legislation similar to what Alaska has. So that's what you have. But there, it also, but the commentary says it is only going to be subject to the claims of your creditors. This is assuming you're not in Alaska or Delaware or Nevada or South Dakota, which permits it. But it can be used true in all states, provided that it's not a trustee who can give it back to you, but it's some independent person. And basically, whenever you create a trust which has a special power of appointment, or it could be decanted to give someone a special power of appointment in an individual capacity, not as a fiduciary, it is not subject to the claims of creditors, even though the person who's got the power of appointment could appoint it back to the grantor. So the special power of appointment trust works the following way. I create a trust for my wife, my kids, maybe my brother and sister, whoever it may be. And the trust says the trustee may never give anything to me on a voluntary basis. Even if there's a decanting, the trustee can never give it back to me. That means that it's not going to be subject to the claims of my creditors in every state in the union. It doesn't matter. And yet that also means that if I give someone a special lifetime power of appointment, which is not a power that they can appoint to themselves, it means that the assets will not be subject to the claims of my creditors. So that's, again, take a look at the commentary to section 505 of the Uniform Trust Code. So you can create a trust for your family. You will be prohibited from ever getting a discretionary distribution from the trust in the discretion of the trustee, but you will have anywhere from 1 to 3 people who can go ahead and appoint the property to you. Because the way I do it, I put in, for example, the one I did, it said that I named 3 people who had this special power of appointment, and they could exercise in favor of any descendant of my mother. Now, obviously, I'm a descendant of my mother, and as a consequence, that person or one of those 3 people could appoint the assets back to me. There's an article in the February 2019 issue of Estate Planning Magazine by Abby O'Connor, Mitchell Gans, and me, and Marty and I have discussed and written on this extensively as well about the special power of appointment trust. And in fact, rather than worry about You know, have I made the trust sufficiently different that the reciprocal trust doctrine isn't going to apply? There's no trust that goes back to the other person. In fact, the trust says it can never go back to me, but it does say that these people have a special power of appointment which they can exercise in favor of any descendant of my mother. And as a consequence, if I need it, I can go to them and they can appoint part of the property back to me. While it's in the trust, it's going to be immunized from claims of creditors. And this theoretically should work in every state in the union. But if you use this, I still recommend you go to one of the states like Alaska or Delaware or South Dakota or Nevada, which permits self-settled trusts that can be immunized from the claims of creditors.
Bob, let me ask you to comment, because I love, and I keep repeating it, the calculus has changed. I think from a client's perspective, the calculus has changed because regardless of what we say, they're not going to have the same fear factor if they're under the 60 million, using your number, of net worth, that they did before the election. But it seems to me that if a client is going to say, let me wait until 3.5 years from now, we'll see what the climate looks like. Why do the planning now? But it seems to me that the calculus has changed. So, client, if you're not as comfortable going ahead and doing that slat that you were planning, how about we give more access to you in the trust? Because what's the downside as long as you have sufficient access, what's the downside? So if you were going to do non-reciprocal slats and now you're hemming and hawing, why don't we do a DAPT or hybrid DAPT for one of you and a SPAT for the other? Now you can both get access in the discretion of the trustee, but if you really need the money, the trustee will take care of you, not with an implied agreement. Why not just change the nature of the drafting, the planning, to have a more robust trust? Does that make any sense? Do you think that's saleable, that would make clients that are waffling more comfortable proceeding?
Well, absolutely. Nobody wants to give up something they worked a lifetime for, generally. The other thing that just hit me as I was listening to you and Jonathan, if I create the slat for my wife in December of 2024, and she creates a slat for me in December of 2028, 4 years between those steps, it's going to be even harder to collapse that. So maybe there's still merit, Marty, in going through with one of the slats in 2024 and then just seeing how all this plays out. But at least you've moved that large exemption. And I think we can put somebody in the same income tax position if we grant the spouse, I do a trust for my wife, if we grant her a contingent general power of appointment, where if she has exemption left over, we'll get a step up on that property.
Well,
So that's something that we really need to look at.
The alternative, Bob, of course, is to have her trigger the Delaware tax trap. That's contained in section 2041A3 of the Internal Revenue Code. And basically, and I'm simplifying it a bit, if someone holds a special non-general power of appointment, which means that it's not going to be treated as in their estate when they die, they can exercise that power in a certain way as described in section 2041A3, so that it is treated as a general power for estate tax purposes, which means it will be in their estate and you will get the stepped up basis. So that's always a possibility that you can consider in triggering the trap without having a general power, because normally in most states, if someone has a general power of appointment, it's subject to the claims of their creditors. This way, they will never hold general power of appointment. They'll hold a special power, which in all states immunizes it from claims of creditors. And then they can go ahead and exercise it to trigger the trap to cause it to be subject to estate tax in their estate. So they get the benefit of, asset protection. They get the benefit of estate tax inclusion with a stepped up basis without fear that it's going to be subject to the claims of the power holders' creditors.
We have
simplistically, well, go ahead, Marty.
No, go on.
Simplistically, they would exercise that power to extend the rule against perpetuities. Is it that simple?
Well, it depends upon the state, but basically it says that If your power is exercised in such a manner so that a new rule against perpetuities period commences, then we treat it as though they had a general power and it comes in their estate. Let me give you an example. Let's say I have a special power and I appoint it in a trust which gives my son the power to withdraw all the property. He has a general power. So I create my special power to give my son a presently exercisable general power. Well, if someone has a presently exercisable general power, it's as though they own the property. So section 2041A3 says, and there's a comparable provision under section 2514. It says, if you exercise the power to commence a new rule against perpetuities period under state law, then you are treated as though you owned it and it will be in your estate when you die. And one of the beauties is you can wait up until the minute before death in order to have the power holder decide whether or not she wants to have it in her estate or not. Jeff Pennell and I came up with this idea, believe it or not, back in 1988. And it's a bully idea, which I just don't think is considered enough.
Let me give you one more thought, and then we have two topics we have to cover before we sign off. We got to talk about asset protection, which I know everybody on the webinar knows about, but we got to talk about it because I think it's critical to be in the mix of the discussions. And Jonathan, you got to explain your thoughts on rescission. But before we do that, what if I set up a DAP, Domestic Asset Protection Trust, in Nevada, and I'm a beneficiary, and then we determine while I'm, on my deathbed or before that, that based on the exemption, my estate, the size of my estate, some of the appreciated assets, that half of that trust, we want to get a basis step up. What if we bifurcated the trust, left half in Nevada, and moved the other subdivided half of the trust back to New York? DAPs are not permitted in New York. Doesn't that create a state inclusion? And that would get me a step up on those half of the assets?
Well, Marty, I think it depends on whether or not the fact that you eventually got a power to appoint it to yourself, but indirectly, whether that would make it subject to the claims of your creditors. I think there's a risk if you do that. And I would urge someone who really wanted asset protection not to do it. But it's not clear that if I create a trust for my wife and my wife then creates a trust for me, or the trustee gives me a power, that would otherwise make it a self-settled trust and subject to the claims of creditors. It's just not 100% sure that that's going to be in my estate. So I think that, triggering the Delaware tax trap is a better way to go forward if that's what you want.
So one of the topics that we didn't talk about, I think we can be quick because it's not really a focus, but it's critical to the discussion of what planning people should do, is to protection. And I think I can speak for all three of us and say we all agree that people of any level of wealth should be taking steps to protect their assets. And people with the level of wealth that would have even entertained the thought of doing a SLAT or any other kind of irrevocable trust plan, why wouldn't they do it just to maintain and obtain the asset protection that having assets in an irrevocable trust provides? And if they're concerned about access, then you go to one of the 22 states that permit self-settled trust, and you do a SPAT or a DAPT or a hybrid DAPT, depending on what you're comfortable with, what level of risk you feel you want to take, and how you assess those different techniques. But I think delaying or not doing planning from an asset protection perspective is a significant mistake. I have currently the first client that I can think of in my entire career, very bright, successful people. They're not concerned about asset protection planning. They do a lot of real estate development. They feel that they've always assessed risks. They're not uncomfortable with the risks that they have. It's the first client that is seemingly made an informed decision that they don't need asset protection planning. I still think it's a mistake because of the level of wealth that they have. Why wouldn't they still protect a nest egg? Because the cost and the hassle of doing so is pretty inconsequential. But Jonathan and Bob, comment on asset protection, because I think any client that defers planning, just because the estate tax environment has changed post-election, is missing a very vital point. This planning should have always been done for asset protection purposes. Comments, thoughts?
absolutely true. And we've established that you can still get the step up in basis on some of that property, depending whether you add the GPOA, go down the Delaware tax trap.
I can use a
So
swap power.
you could use a swap power. So there's really no good reason not to look at that asset protection planning if you have what you perceive to be risk. That you can't, just if husband and wife are both school administrators, their risk is probably covered by an umbrella policy. But if they're a doctor, a dentist, architect, engineer, they have things to worry about.
But even if they're school teachers, they appear to be in an industry where there's no liability. Maybe someone gets killed or injured worse in a car accident, and they come in and the jury awards a $50 million judgment against those people. That happens, and it happens every month in the United States. I mean, there are 20 million new lawsuits every year filed in the United States. And there are a lot of people who have gone bankrupt on account of that. And, when you think you're losing everything, your kids' education isn't, or grandkids' education isn't going to be taken care of. It's terribly stressful. I won't give you the name of a client, but I had a client who was a very great businessman. He thought he was fine, and he went into bankruptcy, and his company went into bankruptcy, even though he had done nothing wrong. And it wound up basically killing him. He died within 2 years. Everything in his life fell apart, even though he was a wonderful man, but just things got out of hand in his life, and he basically lost it all. And he wound up dying basically within 2 years of the lawsuit being filed. Very, very sad. But asset protection is critically important. But, Marty, you have clients who are very wealthy, but they say, hey, we're protected. And I won't give you the name of the client again, but I had a client who said, we're completely covered. And his lawyer said, we're completely covered. And he owned a lot of real estate, and they had insurance and all sorts of things. Well, the lawyer took me to lunch, and we went to a restaurant in a building that he owned. And I noticed that there was a bar that came down at night to prevent people from breaking in. And that at that restaurant, that bar was being held up by a broomstick handle. And I said to the lawyer, by the way, who was a Harvard Law School graduate, what would happen if my shoulder hit that and the broomstick came out and it hit me in the head and I didn't die? I was just crippled terribly. And I had to be taken care of. And that afternoon, they decided that they would start doing real asset protection. It's very, very hard for people because they think, hey, I'm a nice person. Nobody would sue me. I'm a nice person. I wouldn't intend to hurt anybody. But that's not the way the law works. And, if you do good asset protection, it means you can even have less insurance. Rather than having a $20 million umbrella policy, maybe you only have a $5 million umbrella policy, whatever it is. But you can sleep better at night if you know that your assets are protected. And the time to do that is when you don't think you have any problem in the world. Do it now.
Jonathan, we've left the most exciting topic for last, and then we can wrap up with some suggestions and comments. Talk about rescission. What does rescission and the proposed regs on rescission have to do with the Republican victory and planning that we might talk about with clients? Can you give me a note for a promise for a note?
Well,
how does this all change?
Well, people are trying to come up with ways. This goes back to 2010. How can I use my exemption but keep the assets? So one of my former colleagues, Austin Bramwell, who's a partner at Milbank Tweed, well, I guess it's just Milbank now, they've dropped the other names, where he said, make a promise to make a gift, and that gift will be complete, but so you're using your exemption, yet you will continue to own the assets. Well, the IRS agreed that that would work, except they came out with clawback rules that basically, if you use your exemption that way and you do certain things like make a gift by a promise without transferring the assets, or you make certain other transfers, the IRS, the Treasury Department, has issued regulations saying, guess what? it's all going to come back in your estate. You will not have effectively used it. So that is there, and you've got to be very cautious. For example, Steve Brightstone has come up with a great idea on having a defective partnership where you've made a big gift equal to the value of what you put in the partnership, but you still own the assets. You can still get distributions. Well, that would work in using the exemption. You keep the assets, but it won't work under the clawback regulations. And it won't work where you make a gift by making a promise. But it appears that if we do not have a reduction in the exemption, those rules on the clawback won't apply. So if you say, well, maybe that's what I ought to try to do. I ought to do it. If it doesn't work, it doesn't work. But if they do not reduce the exemption, then I've done a great thing. I've been able to make this huge gift and keep the assets in my own name without worrying about a clawback when I die.
And I think if anyone wants more information on the clawback regs, which goes through all these different techniques, I think the three of us actually did a webinar on the clawback proposed regs.
We did.
Yes? Very exciting viewing, I may add. Bob,
we did, but
talk to us. Wrap up.
I think we need to revisit Jonathan's point. So let's just look at the Brightstone technique with a partnership. Under Section 2701, a partnership, freeze partnership, has to be structured following the statute. And if you fail to follow the statute, you're deemed to gift away the preferred your gift to give away the preferred you retain. You burn up your exemption. This may be a way for people to burn up their exemption. I think what we have to do, Jonathan, is revisit with no clawback whether there's any techniques out there we're missing where people can keep more of their property and still have a good estate tax result.
Gift by promises is perhaps the best way. Now, Austin wrote an article about this. Mitchell and I considered this even before, but you can't make a gift by making a promise except in the state of Pennsylvania. If you make a promise to someone and you want to document it, even though you haven't transferred any property to them, you have now made a gift for federal gift tax purposes. So I go to the trustee and you have questions about valuation, about how much is the promise worth. But I promise to give, my trustee, this trustee, $20 million. And I have it increase every year by some factors. So even though the transfer won't happen until a later time, you've made a gift today. So I've now made a gift of $20 million, and yet I've retained the assets. So that appears to be the best of all possible worlds. Now, the only state where that can happen for sure is Pennsylvania. Although, as Austin discusses in his article, there are ways in which you can kind of do a defective transfer. But if you were going to do this, and I thought about doing it, and so did Mitchell, we go to Pennsylvania where my wife's family lives, and I'd have one of my wife's relatives be the trustee, and I would give that trustee an enforceable promise under Pennsylvania law for $20 million on a present value basis, and I will have now made a gift of $20 million. And yet I will not have transferred any of my assets. Now, there are questions about, suppose I don't have 20 million today, what happens if I make transfers in the future? But the gift would be complete at the time that I make the promise. And that's something that you can consider for your client. So it's, again, you can't do it now under the proposed regulations on clawback, which if there's a reduction in the exemption, it doesn't work. But if it turns out that there is not going to be a reduction in exemption, you can use this gift by promise technique, make a gift, you'd report it on a return, and yet you'd keep the assets, which is kind of the best of all possible worlds, except you're missing out on having transferred the assets. I like the clients to transfer the assets because now they're immunized for claims of creditors, not just mine, but of the beneficiaries as well, by creating a by creating a spendthrift trust. Very, very important. And keep in mind, more money is lost each year to creditor claims than to estate taxes and to gift taxes. So, I mean, I've had clients lose it all, and because just bad things happen in their lives. So you always, and this is an always rule, want transfers to be made as early in life as possible to use the exemption and to provide asset protection. Even if you're going to be a beneficiary of the trust, either because it's a special power of appointment trust, where you're giving someone else in the family the power to appoint it back to any descendant of my mother, which would include me, or because you're using a self-settled trust in Alaska, Delaware, or wherever. But those are some of the things that people need to consider. But it is very, very hard for people to say, hey, I'm a nice person. Nobody is going to sue me. Well, guess what? There are 20 million new lawsuits commenced every year in the United States. Protect your assets, protect them for your family, and protect them for yourselves.
And again, I'm going to use the same analysis that I did on doing the exemption planning, even if you're not as confident the exemption is going to go down. If somebody's worth 20, 30, 40 million dollars, even $10 million, the cost of creating a SPAT adapt, a hybrid adapt, even a SLAT, whatever's appropriate based on the analysis, is inconsequential compared to their net worth. And I agree with Jonathan on these asset protection worries 1,000%. The stories that we've seen as estate planners over the decades of practice are awful and terrifying. So many people are good, decent people that have been very careful in everything that they've tried to do have gotten nailed. So to me, that alone is the reason that planning should continue. Even for the client that I have that feels they're not worried about it, I think that's a mistake. I can't change their mind, nor do I want to, but I think it's a mistake. Jonathan, one quick comment on clawback, then Bob, I'm going to flip it to you to wrap up and conclude for us. If we think we can now use the proposed clawback regs to come up with techniques to use exemption, if the exemption doesn't go down, the proposed clawback regs are kind of irrelevant. And they're not binding yet because it's only, I believe, still proposed. I don't think they've ever been finalized unless I'm wrong. Is that correct?
I believe that's the case. It's a proposed regulation. Now, they say it's going to be retroactive to the date of introduction, but I'm not even sure that's going to happen because you have a new Treasury Department. I mean, I don't know whether, whether Mnuchin is going to come in as the Treasury Secretary. It's certainly not going to remain to be Janet Yellen. So, I don't know what will happen, but I think there's a good chance that the clawback regs will not be very effective.
But here's the question, then I'm going to let Bob wrap up. If the exemption does go down and I've made a gift of a promise, will it really work to have used my exemption? Because it seems like the only way the clawback regs, leaving aside that they're proposed and may not be finalized, but let's assume they were final. If the clawback regs work or apply, my gift by promise, if the exemption goes down, the clawback regs would apply, it won't work. In other words, it only works if I didn't need it because of the reduction in the exemption. In other words, if the exemption is not reduced, I didn't need to do it. The exemption is reduced, it doesn't work. So I think it's an interesting theory, but does help me.
Bob, you're muted.
We're going to have to explore that, Marty, on whether any of those techniques can mathematically help us.
I think they're interesting concepts that Jonathan brought up because I think it makes a world of sense for clients that are fence sitters to give them these options because it's still a level of planning. I think Jonathan's point about the lack of asset protection is the most important aspect of it. But I think this also highlights how complicated it is to rethink everything that we do in light of the recent political development that, I thought we'd be doing a program post-election about, what the Harris tax plan would look like. And it's not at all the case. So, Bob, why don't you wrap up, and Jonathan, if you have any final comments, and we should conclude.
I think we can start with the premise that the steep demand for SLATs, which has been driving a lot of planning for the last year, and we thought would drive planning for the next 12 months, is going to be reduced. However, the to keep your momentum in your practice, it's pivot to other things you can bring to the same clients. Can you coach them up on Roth conversions and get someone to study those Roth? I'm talking to the lawyers. Can you show them how Roth conversion may be efficacious in their situation? Get somebody to run those numbers. If somebody dies, when you evaluate portability, look at it through the lens of a reduced exemption at some point in time in the future. That is so important. And we just have to continue. People are missing these portability returns all the time. On the income tax planning, Marty, we could spend hours teaching people how to do charitable lead trusts, grantor and non-grantor, how to do charitable remainder trusts, 453 installment sales. There are what I'll call statutorily blessed income tax planning techniques that have no risk. They're black letter law that can be put in place for clients. And for a good estate planning lawyer to learn those techniques is not a big thing. It's not a quantum leap. It's already you have 80% of the knowledge you need. And then finally, to what you and Jonathan just wrapped up on asset protection planning, very serious stuff. And we can still move quite a bit of property, get it into trusts, and there's asset protection reasons. So I think with the number of people born between 1945 and 1962 or 63, there's just so much work out there. And it's just a matter of changing your skill set a little bit.
Jonathan, any final?
No, I thought what Bob said was just about perfect, Marty.
I think if you go through the comments we've made on the program, there's a lot of techniques that we kind of have in our toolkit, but maybe they're in the back of the toolkit. Maybe brush them off and bring them up, because we need to give options to clients, because they're going to question, does it make sense to plan? And I think we'll agree, yes, it does, but that planning may be a little different. And hey, client, there's some other ways you may want to, approach it. So thank you all for joining us. Jonathan, thank you for all the usual words of insight, and you too as well, Bob. And I wish us all good luck, and I'm sure we'll do another program as things evolve. Take care, everyone, and good luck planning, and communicate with your clients.